Most true crime begins with a question. Who did this? Where did they go? What are we missing? This one began with an answer. On the afternoon of February 24th, 2020, a 911 call came in from an apartment in Winter Park, Florida. A woman told the dispatcher her boyfriend was dead. Deputies from the Orange County Sheriff's Office arrived, and within a matter of days, investigators had something that almost never exists in a homicide case. Contemporaneous recordings of the hours in question, made by the only other person in the room. There was no manhunt, no unidentified suspect, no forensic puzzle waiting on a lab. And then the case sat, unresolved, for 4.5 years. That gap, between a case that was evidentially simple and a prosecution that took nearly 5 years to reach a jury, is the part of this story that almost never gets told. It is also the part with the most to teach, because what happened in that Orlando courtroom between 2020 and 2024 says less about one night in an apartment than it does about how the American legal system handles a defendant who will not, or cannot, work with anyone assigned to help her. This is not a retelling of the suitcase case. It's an examination of what the suitcase case exposed. Sarah Boone was 40 years old in February 2020. Jorge Torres Jr. was 42. They shared an apartment in Winter Park, a leafy suburb just north of Orlando, and by every account offered later at trial, their relationship had been volatile for a long time. On the evening of Sunday, February 23rd, the two had been drinking. What happened after that would be described over the next 4 years in several competing versions, but the physical outcome was never disputed. Torres ended up inside a large piece of luggage. The zipper was closed. He remained there for hours. He did not survive the night. The medical examiner's findings pointed to positional asphyxia. Reports also documented bruising and abrasions across his head, back, and hands, injuries consistent with blunt impacts, and injuries that did not match the account Boone initially gave. That account was, in her telling, a game. The couple had been playing hide-and-seek, she said, and Torres had climbed into the suitcase himself. She thought it was funny. She believed he could get himself out. She fell asleep upstairs, and when she woke, he was unresponsive. It is worth pausing on how quickly that story came apart, and why, because the mechanism is instructive. Investigators did not break the account through interrogation pressure. They broke it with her own phone. 2 video files, recorded while Torres was inside the suitcase, captured him telling her he could not breathe. Her responses on those recordings were not the responses of someone who believed she was watching a game. This is what forensic interviewers call an anchoring problem. Once a suspect commits to a version of events in the first hours, before they know what evidence exists, every subsequent correction reads as consciousness of guilt rather than clarification. Boone gave statements at the scene, and again the following day at the sheriff's office. Detectives arrested her after determining her statements were inconsistent. She would spend the next 4 years trying to replace that first version with a second one. The trouble was that the first version was already in the record, and the recordings were already in evidence. And juries are extremely good at noticing when a story arrives after the evidence rather than before it. Here is a detail that shifts the shape of this case, and it is one that a lot of coverage flattened. This was not a couple with no history. Both of them had been arrested before in incidents involving the other. The relationship had generated police contact in both directions. That fact does real work, for the defense and against it simultaneously. For the defense, it was the foundation of everything they would eventually argue, that Boone had lived inside a pattern of violence long enough that her perception of danger no longer matched a stranger's. For the prosecution, it complicated any clean narrative of a battered woman and a batterer, because the paperwork did not point in one direction only. And for anyone studying how these cases actually work, it illustrates one of the hardest problems in domestic violence policing: bidirectional violence. When officers arrive at a scene where both parties have injuries and both parties are accusing the other, they are typically required to make a primary aggressor determination, an on-the-spot judgment about who initiated and who responded. It is a genuinely difficult call made under time pressure with incomplete information, and research on dual arrest policies has consistently found that they can obscure ongoing patterns of abuse rather than clarify them. A woman who fights back can end up processed identically to the person who has been hurting her for years. A man who is being harmed can end up dismissed because he does not match the expected profile. The practical consequence is that a relationship can accumulate a long paper trail without ever triggering the kind of intervention. A sustained protective order, a supervised separation, a referral that actually takes, that changes the trajectory. That is the missed warning sign in this story. Not a single dramatic moment that someone overlooked. Something duller and more common. Repeated contact with a system that logged each incident, closed each file, and moved on. By February 2020, the record on that apartment was already thick. It had simply never added up to anything. Now we come to the part of this case that is genuinely unusual in American criminal procedure. Between her arrest in 2020 and her trial in October 2024, Sarah Boone went through 8 attorneys. 7 of them were court-appointed. One after another, they filed motions to withdraw, citing variations on the same theme, irreconcilable differences, an inability to communicate, a breakdown in the working relationship. She walked out of conferences. She wrote letters to the court about her lawyers. One of them ran 58 pages. Then, in the summer of 2024, Judge Michael Kranick did something judges very rarely do. He ruled that Boone had forfeited her right to court-appointed counsel. In his written order, he observed that it had become clear the defendant would not permit herself to be represented by anyone. He noted she had been warned before and warned about the dangers of self-representation. He wrote that appointing yet another lawyer would serve only to delay the case further. And he set trial for that October, adding that it would not be continued except for extraordinarily good cause, and that hiring a new lawyer would not count as one. To understand why that ruling matters far beyond this case, you need to understand the distinction courts draw between 3 things that sound similar and are not. Waiver is when a defendant knowingly and voluntarily gives up the right to a lawyer and chooses to represent themselves. That right was established by the Supreme Court in Ferretta v. California in 1975. It requires a hearing. The judge has to confirm the defendant understands what they are giving up. Forfeiture is different. Forfeiture is when a defendant loses the right through their own conduct, not because they chose to, but because they made representation impossible. It does not require the defendant's consent. It is, in effect, a sanction. Waiver by conduct sits between them. A defendant who has been explicitly warned that continued obstruction will cost them counsel and who continues anyway. Kranick's order invoked both forfeiture and waiver by conduct. That belt and suspenders approach is telling. Judges who take this step know they are building something an appellate court will inspect closely, because the right to counsel is among the most protected rights in the system, and stripping it is the kind of ruling that gets convictions reversed. What followed was, by any measure, chaotic. Boone appeared at hearings as her own lawyer. She asked for standby counsel and was denied. The judge reasoning that having forfeited her right to appointed counsel, she was not entitled to a lawyer standing by either. She argued with him about it directly, telling him she had never wanted to be pro se in the first place. She wrote a handwritten advertisement from jail seeking a new attorney, describing the opportunity awaiting whoever took it. The ad worked. Media coverage circulated it, and a private attorney named James Owens saw it and volunteered, taking the case without charge weeks before trial. He became her 9th attorney. Here is the analytical point that gets lost in the spectacle. The 4-year delay was not neutral. It changed the case in at least 3 concrete ways. First, it produced enormous pretrial publicity. Boone herself raised this, at one point submitting a map to illustrate how far coverage of her case had spread. By the time a jury was selected in Orlando in the fall of 2024, The pool had been marinating in this story for years, much of it framed around her courtroom behavior rather than the evidence. Second, it meant her trial defense was assembled in weeks rather than years. Owens inherited a case with a mountain of discovery, an expert strategy to finalize, and a client with a documented history of clashing with counsel. Third, and this cuts the other way, the delay handed the defense an appellate issue that a smooth prosecution never would have created. If a court of appeal ever concludes that the forfeiture ruling went too far, everything downstream of it becomes vulnerable. Judges face a genuine bind here, and it deserves to be stated fairly. A defendant who cycles through counsel indefinitely can effectively veto their own prosecution. Victims' families wait. Witnesses' memories decay. At some point, a court has to be able to say no. But the tool for saying no is blunt, and it is aimed at the single right most likely to make a trial fair. The trial opened in October 2024 and ran roughly 2 weeks. Before it began, there was an offer on the table, a plea to manslaughter carrying a sentence in the range of 15 years. Her attorney urged her to take it. She refused. That decision deserves more than a passing mention because plea math is one of the least understood parts of the criminal system. Well over 90% of felony convictions in the United States come from pleas, not trials. Defendants who reject offers and lose at trial routinely receive dramatically longer sentences. A differential researchers call the trial penalty. Boone was facing a second-degree murder count in Florida where the sentencing exposure runs to life. She turned down 15 years and went to trial on a charge that could cost her the rest of her life. And then she made a second high-risk choice. She testified for roughly 5 hours. Defense attorneys are trained to fear this, not because defendants lie, because the moment a defendant takes the stand, the case stops being about whether the state met its burden and starts being about whether the jury likes and believes the person in front of them. Every prior inconsistent statement becomes fair game. Every shift between the 2020 account and the 2024 account can be laid side by side, and in this case, the shift was substantial. The version given to deputies in 2020 was a game gone wrong. The version presented at trial was self-defense, that Torres had threatened her, that she believed she could have been seriously harmed or killed. Both cannot be the first thing that happened. Prosecutors made that the spine of their closing. The truth does not change, they told jurors. The facts do not change. The defense at the center of this trial was widely reported as battered spouse syndrome. It is also, in my view, the single most misunderstood element of the entire case. So let's take it seriously, because there is real educational value here. Battered spouse syndrome is not a defense. It is not a verdict category. It is not a formal diagnosis in the primary psychiatric manual, a point the state made explicitly on cross-examination at trial. What it is, in most American jurisdictions, is evidence. Expert testimony offered to help a jury understand why a person who has lived through prolonged intimate partner violence might perceive danger or respond to it differently than an outside observer would expect. It exists to make behavior legible that otherwise looks irrational. Why someone didn't leave, why someone didn't call police, why someone's fear seems disproportionate to a single incident when it is actually calibrated to a pattern. Critically, it supports a self-defense claim. It does not replace one. And self-defense in Florida, as in nearly every state, has an element that decided this trial: imminence. The force used must respond to a threat of harm that is happening or immediately about to happen. Not a threat that occurred earlier, not a threat expected later. That requirement is where this defense ran into a wall it could not get over. Both sides put mental health experts in front of the jury. A forensic psychologist called by the defense testified that Boone met the criteria and described patterns ingrained in her behavior, and also diagnosed post-traumatic stress disorder rooted in intimate partner violence. Notably, the the state's own expert did not simply reject the diagnosis. She agreed with it, and then made the distinction that mattered, telling jurors that having battered spouse syndrome does not by itself justify actions taken against a partner. That is a genuinely important moment, and most coverage skated past it. The jury was not asked to decide whether Sarah Boone had been abused. The jury was asked whether hours of inaction, while the other person was contained and pleading, could be self-defense. Under Florida's imminence requirement, it is very hard to see how it could be. This is the uncomfortable insight the case offers, and it is worth sitting with. A defendant's account of abuse can be entirely true and still fail as a legal defense. Those are separate questions. Our public conversation constantly collapses them, treating an acquittal as proof the abuse was real and a conviction as proof it was invented. The law does no such thing. It asks a narrower question than the public does, and it asks it about a much smaller window of time. Prosecutors, meanwhile, built their theory around motive rather than plan. Their argument was that this was punishment, that she wanted him to experience what she said he had made her experience, and that she went upstairs and left him there. That framing tracks the actual charge precisely. Second-degree murder in Florida does not require premeditation. It requires an act demonstrating a depraved mind, extreme indifference to human life, without any need to prove advanced planning. The state did not have to argue she woke up that day intending to kill anyone. It only had to convince 12 people that leaving him in that condition showed a fatal indifference to whether he lived. The jury deliberated for roughly an hour and a half for a 2-week trial involving competing expert testimony, 4 years of pretrial history, and a defendant who spent 5 hours on the stand. 90 minutes is not deliberation in any meaningful sense. It is confirmation of something already settled. Verdict: guilty of second-degree murder. At sentencing in December 2024, Torres's family spoke. His mother told the court that Boone had not only killed her son, but a father, a brother, an uncle, and described still finding herself watching the window, waiting for him to come home and say he loved her. It is one of the most quietly devastating things said in that courtroom, and it is worth remembering that Jorge Torres Jr. is a person in this story and not a plot device. Boone spoke as well, describing the abuse she said she suffered and saying she forgave herself for having loved him. Judge Cranick sentenced her to life in prison. She is serving it at Lowell Correctional Institution. The pattern that defined the pretrial years did not stop at conviction. Boone's appeal was docketed in Florida's 6th District Court of Appeal, and the churn continued. By late 2025, Court TV reported she was on her 13th attorney overall, her 4th on appeal alone. One withdrew days after being appointed. One stopped doing appellate work. One took a different job. She filed handwritten motions asking simply to be told who her lawyer was and what the status of her case might be. The court granted extension after extension, eventually warning that no further ones would be given absent extenuating circumstances. An initial brief was finally filed in the spring of 2026, more than a year after sentencing, with legal commentators reporting that it centers on jury instruction issues and a discovery dispute from trial. The state has since responded. As of this recording, the appeal remains undecided. It's worth being clear-eyed about what appeals do and don't do. An appellate court is not a second jury. It does not reweigh evidence or decide whether it would have reached a different verdict. It looks for legal error serious enough to have affected the outcome, which is why the most substantial issue in this case is probably not the psychology or the videos. It's the counsel question, whether a defendant can be stripped of appointed counsel for obstruction, and whether the procedure used to do it here met constitutional standards. That is exactly the kind of question appellate courts exist to answer, and it is the reason this case may end up mattering to defendants who have nothing else in common with Sarah Boone. So why does this case matter? Not because the facts were hard. They weren't. If anything, this may be one of the most thoroughly documented domestic homicides in recent memory, and that documentation is precisely what makes it useful. It matters because two systems met their limits here, at opposite ends of the same story. At the front end, a domestic violence apparatus that logged incident after incident in a volatile household and never converted any of it into an outcome that separated two people who were clearly dangerous to each other. Bidirectional violence is not a rare edge case. It is a recurring blind spot, and it is where the system's tools work worst. At the back end, a court system built on the assumption that defendants will participate in their own defense, and largely without good options when one doesn't. 4.5 years, 9 trial attorneys, a judge forced to choose between an indefinite delay and a ruling that may yet come back to him. And running alongside both of them, us, the audience. The pre-trial hearings became content. The letters became content. The handwritten attorney ad went around the internet as a joke. It's fair to ask whether years of watching a defendant as a curiosity made it harder to evaluate her actual claims, and whether we would have processed her defense differently if we hadn't spent 4 years being entertained by her. None of that means the verdict was wrong. The evidence in this case was about as direct as evidence gets, and 12 people needed 90 minutes with it. But a system can reach the right answer and still show you every place where it nearly didn't. Judges almost never strip a defendant of court-appointed counsel, but a defendant who goes through 8 lawyers can effectively stall a case indefinitely. Where should that line be drawn? Let us know how you'd handle it in the comments. Cases like this remind us that some questions continue long after the headlines fade. If you found this documentary informative, consider subscribing for more carefully researched true crime stories. We'd also love to hear your thoughts in the comments below. Thank you for watching, and we'll see you in the next documentary.